Can you hear me standing here behind the microphone? Good, thank you. I'm not going to welcome you for that because that's for our very distinguished chair. Rather unorthodoxly, I just wanted to introduce the chair because of the kind of chair that he is. I think although the Bingham Centre was launched 3 years ago, it may not be before this very distinguished audience necessary to introduce it to you. For you will know that it seeks to define and implement and further the rule of law in different ways. It highlights threats to the rule of law. It conducts studies on the rule of law, training on the rule of law, always seeking practical outcomes. And it supports capacity building to promote a wider practical application of the rule of law among governments, decision makers, NGOs, the wider public, and so on. We work with like-minded bodies, and we're working in places such as Burma, Myanmar, where we have had buses rolling through the country from village to village, explaining the nature of a constitution, what the Burmese constitution is, what kind of changes could there be. We're working also with the Burmese Parliament and its Rule of Law Committee, chaired by Aung San Suu Kyi. We've been working in Bahrain on matters such as drafting laws for freedom of expression and assembly within the international legal human rights standards. And alas, we cannot ignore matters in this country, so we've been responding to the various papers about judicial review, and most recently have been doing our own independent study to see in what way the procedures of the administrative court and judicial review in general might be streamlined, but in accordance with the rule of law. So in that and in other ways, we seek to be constructive. The topic for tonight was brought to our attention by first reading the reports of the debate, reading the issue as it has been debated, and led by Lord Lloyd and others in Parliament. And it seemed to us a matter that really deserved an airing at this point. And thanks to Lord Lloyd for agreeing to be the principal speaker, for providing much of the background, and for his general strong support of the Bingham Centre for the Rule of Law. Of course, he was a personal friend of Lord Bingham, after whom the centre is named. So let me hand over now simply to introduce our chairman. He has officially retired, so we're particularly privileged that he's agreed to chair this meeting tonight. I think that all one can say about Sir Sydney Kentridge is that he is probably, except I will now remove the word probably, and say that he is the greatest lawyer of our time, Sir Sydney Kentridge.
Well, given that introduction, I suppose I'd better say something about Sir Geoffrey Joe. He is the director of the Bingham Centre for the Rule of Law, and we're very grateful to him for agreeing to host this evening, to host this panel discussion, and also for organizing it together with the Centre's research fellow, Jan van Zyl-Smit. I don't think that those of us at this side of the table would have been capable of organizing it, and they have got us a number of very distinguished speakers. The subject may be a little unfamiliar to some of you, and I perhaps should say to some of us here too. The subject is indefinite imprisonment for the public protection, which is shortly known as IPP. It's a form of imprisonment introduced by a statute in 2003, and the point of it is that if someone who had a previous conviction for a particular serious offence, usually a violent offence, came before the court again and was convicted, he could be sentenced to indeterminate detention, whatever the nature of his offence, his latest offence, even if it was not a particularly serious one. The problems of that became obvious, and in 2012 Parliament repealed the law which provided for this indefinite detention, so that was the end of it, one would have thought, only it wasn't, because those who were at that stage already in indefinite imprisonment were not released, and they are still there, or at least some 5,000 of them are still there. And of course the fact that they are still in prison, notwithstanding the repeal of the law which sent them there, raises a number of issues and problems. Obviously legal ones, including, of course, human rights law, criminal law, and prison law. It also raises also problems for those who administer prisons, and of course for the prisoners themselves. There are also political issues which arise. Political in the broad sense, that is to say, the issue of the protection of the public, and also possibly the issue of public opinion. And overriding it all, also in the broad sense, is the issue of justice. Now we have 5 particularly well-qualified people on the advertised panel to deal with these problems. First, there is Lord Lloyd, retired Lord of Appeal, who has been instrumental in raising this issue publicly. He has taken it up with ministers, and he has also taken it up with the House of Lords, where he has tried, so far without success, to get an amendment in the law. And I should say that in addition to his status as a very distinguished law lord, when he was in the Queen's Bench Division, he was also a member of the Parole Board. He is going to be followed by Juliet Lyon CBE, who is the chairman of the Prison Reform Trust. She has for years worked with prisoners and in and about prisons. She is an experienced psychologist, and she has been an independent advisor to a number of official review bodies who were dealing with questions of the treatment of prisoners and of detentions in prison. And her knowledge of what happens in prisons and what happens to prisoners, both in prison and when they are out, is probably unrivaled. Then we are going to have Sir David Calvert-Smith. When he was at the bar, he was the senior prosecuting counsel at the Old Bailey for some time. He then became the director of public prosecutions. He was appointed a judge of the Queen's Bench Division. He is now retired from that, and appropriately enough for us this evening, he is the chairman of the Parole Board, and therefore, as part of his remit, he has to deal with, among others, the sort of prisoners who are now in this system of indeterminate imprisonment, and he deals with them when they apply for parole. And you'll hear this evening about the problems of parole under the existing law. He is going to be followed by Pete Weatherby QC. Pete Weatherby is an experienced counsel in many fields. But among them is criminal law, including human rights law, and also prison law. He was the counsel in the leading case on what we call IPP, which went through the English courts and was taken by him to the European Court of Human Rights with, as perhaps he'll tell you, some success. The fifth name on our list is Lord Fawkes QC, who is a minister in the Department of Justice. Unfortunately, there is a division in the House of Lords this evening, and he is required to be present for it. I don't know whether he will still be able to join us. I hope so, but possibly not. Now, I've said that there are, in a prison population in this country of about 85,000, there are still 5,000 of these people undergoing indeterminate imprisonment. Their numbers will not increase, and over the years as they go by, presumably more and more of them will gradually be released. By definition, as prisoners serving the indeterminate sentence, they are people who have all committed at least one very serious crime, usually a crime involving violence. And some may ask, why in that case should we be worrying about these 5,000 prisoners? Why should the busy people who are on the panel have taken time to raise the issue, and why are we all here listening to it? One possible answer was given by a previous Home Secretary in a speech in Parliament, and I would like to read you something of what he said. He said this: "The mood and temper of the public in regard to the treatment of crime and criminals is one of the most unfailing tests of the civilization of any country. A calm, dispassionate recognition of the rights of even the convicted criminal, a constant heart-searching by all concerned and charged with the duty of punishment, a desire and eagerness to rehabilitate those who have paid their due in the hard coinage of punishment. These are the symbols which, in the treatment of crime and criminals, mark and measure the stored-up strength of a nation." That speech was made in 1910, and the Home Secretary was Winston Churchill. I'd now ask Lord Lloyd to open the batting.
Now to refer to opening the batting, I just happened to be wearing my Rambler's tie, but that was not arranged in advance. But I start by thanking Sir Geoffrey Joel and the Bingham Foundation for organising this event. If the event is a success, as I obviously hope it will be, then it will be due entirely to Lord Bingham's name and Lord Bingham's memory and the Foundation's efforts in bringing us all together. Secondly, I want to thank Sir Sydney Kentridge for introducing us. We could not have a more distinguished chairman than him. Sir Geoffrey referred to him as being the greatest lawyer of our time. I prefer to think of him as the greatest advocate. If I had to list a few names of the greatest advocates that I've heard in our courts, then I would certainly include Sir Sydney in the top three, possibly even the top one of all. Let me just give you an example of his advocacy. He had to open an appeal in the House of Lords in the old days. And he opened the appeal in this way. He said, "My lords, in this case, I have the most difficult task that can befall an advocate, a barrister, and that is to persuade your lordships that the decision of Lord Justice Lloyd in the court below was wrong." Now, that was pure advocacy, because before he'd said anything at all, he'd got the law lords on his side. So I do suggest that any advocates here present who are still practicing might try that on and see if it works. Lastly, of course, I have to thank you all for coming, because the purpose of the event is to really draw your attention, and through your attention, perhaps the attention of others, to the 5,000 prisoners that Sir Sydney has just mentioned, currently serving indefinite sentences for the protection of the public under Section 225 of the Criminal Justice Act 2003. And now I will just very briefly give you an outline of the background for those who are not familiar with it. The section was, as Sir Sydney has explained, repealed in 2012. So the power to impose an indefinite sentence no longer exists. It goes without saying that the courts can still impose a discretionary life sentence in the most serious cases, and a mandatory sentence, of course, in the case of murder. But in the discretionary life cases, the tariff or minimum period to be served before the prisoner can be considered by the Parole Board is typically about 8 or 10 years. The IPP sentence was intended to serve an entirely different purpose. It was intended to cover the less serious offences where a life sentence would not be justified. For this new sentence to be available, the offender must have committed a serious offence, been convicted of a serious offence, carrying a maximum sentence of 10 years or more. Although described as serious, the list of qualifying or trigger offences included many what one might call run-of-the-mill offences, crimes such as burglary, robbery, and simple arson, not the most serious of offences. In addition, there had to be a significant risk, those are the words, of the offender committing further such offences. If these two conditions were satisfied, then the court was obliged to pass an IPP sentence with one only very, very limited exception. The word in the statute is must, not may. As to the second condition which I've mentioned, the judge was bound to find it satisfied. In other words, he was bound to assume there was a risk, as described, if the offender had committed a similar offence in the past. So the judge, as you will see from that, had very, very little, if any, discretion in the matter. As with the life sentence, the judge was required to impose a tariff. In practice, judges always arrived at the tariff by taking the sentence they would have imposed as a determinate sentence and then halving it. Why halve it? For the simple reason that they must take account of early release, whereby prisoners serving determinate sentences are released at the halfway stage. So if the notional sentence for the crime they were considering was, let's say, 4 years, then the tariff would be fixed by the judge at 2 years, and then he would make the sentence indeterminate. Lastly, and this was absolutely crucial as it turned out, the sentence had no limit, no minimum tariff limit. Not 2 years, not 1 year, nothing. Then one comes to the expectations at the time the new sentence was created. Well, there's little to go on about that, but it is clear that the government expected a very limited uptake, a few hundred offenders a year at most. Baroness Scotland in the House of Lords referred to a small group of offenders for whom a determinate sentence would not provide a sufficient guarantee of public safety. Thus, it was predicted that the introduction of the IPP sentence would be what is called resource neutral. In other words, any cost would be met by other savings. No additional money for the purposes of this offence was provided. So that was the government's expectation. I do not know whether they made a formal impact assessment. I suspect they didn't. But if they did, the impact assessment was disastrously wrong. Since the sentence was in effect mandatory, as I've described, and since there was no minimum tariff, as I have said, what were they to expect? What they got was a massive increase in the lifer population, for which the government had made no preparation. Many of those given IPP sentences had a tariff of 2 years or less, some even less than 6 months. In the year following the Act coming into force, the average tariff of all IPP sentences was only 30 months. Not surprisingly, the lifer population increased in 1 year by a third. In April 2005, 5,800 prisoners were serving life sentences. 2 years later, in April 2007, the life population was just under 9,000. The result was that the prison system was completely swamped, a word used by Lord Brown in the James case. Lord Hope said that the Secretary of State had failed deplorably, his word, in the public law duty which he had accepted when he persuaded Parliament to introduce IPP sentences. Lord Judge and Lord Carswell were equally severe in their comments. By 2007, the number of IPP prisoners was increasing at the rate of 1,800 a year. Very few of those serving short tariffs had been released because insufficient courses had been made available for them to satisfy the Parole Board that they were safe to release. Clearly, something had to be done, so in 2007, Parliament amended the 2003 Act. Risk was no longer to be assumed by the court, as it had been. The word must was changed to may. Thus, the sentence was no longer mandatory. Above all, the sentence ceased to be available if the appropriate tariff was less than 2 years. But, ladies and gentlemen, it was too little and it was too late. In the House of Lords, I put down an amendment in 2007 to make the minimum tariff 4 years rather than 2 years, as proposed by the government. But the government would not accept it. Thereafter, various expedients were tried without success until 2012, when the sentence was abolished. I can think of no sentence in recent years, or indeed at all, which has had so short a life on the statute book, which was introduced with so little thought for the consequences, and which has left behind such a strong sense of injustice. I know that because of the many letters I and others have received from the prisoners themselves and from their families. Before leaving the statistics and getting on to other things, there's one other set of figures which I should mention. They were given by Baroness Stern in our debate in March last year. They provide the background to what we are discussing. These are the figures. We have 5 times as many prisoners serving life and indeterminate sentences per 100,000 of the population as Germany. 7 times as many as Sweden, 8 times as many as Holland, and 14 times as many as France. I've been told, though I've not been able to check, that we have more prisoners serving life sentences in this country than in the whole of Europe together, including Russia and Turkey. That seems to be no explanation that I can think of for this extraordinary imbalance between this country and other countries, except possibly the desire of successive governments to be, or at least to seem to be, tough on crime and tougher on the other side than the other side. I said in starting that the purpose of the meeting was to draw attention to the 5,500 prisoners serving indeterminate sentence, of whom 3,500 have now passed their tariff date, many by several years. However, there is a more urgent purpose. Can anything be done to speed up their release? The current release test for IPP prisoners is exactly the same as it is for life prisoners. The Parole Board can only direct release if it is satisfied that the confinement is no longer necessary for the protection of the public. Currently, IP prisoners are being released by the Parole Board at the rate of 400 a year. At that rate, it will be 9 years before the backlog of 3,500 prisoners is cleared. This is bad news for all of them, but especially for the 773 prisoners who were given tariffs of 2 years or less before 2008. Of these, 275 are already 5 years over tariff, including 26 whose tariff was only 6 months or less. How much longer, one can surely ask, must these people have to wait? I come then last to what might be a way ahead. When Parliament passed the 2012 Act, it was well aware of the existing backlog. It made specific provision to deal with that problem. Section 128 of the 2012 Act envisages that the release test for IP prisoners need no longer be the same as the release test for lifers, other lifers. It gives the Lord Chancellor power to lay an order before Parliament requiring the Parole Board to direct their release if satisfied that certain conditions are met, or unless satisfied that certain conditions are met. The precise difference between those two alternatives has escaped me, I have to say, but one thing is absolutely clear, that Parliament intended the Lord Chancellor to have these powers in order to speed up release. There is nothing in Section 128 which allows for this new release test, either expressly or by implication, which says that the new release test must depend on the current or any current assessment of risk. So the questions now are two. First, whether the Lord Chancellor should exercise the power which he has been given for that purpose. And second, if so, what the new release test should be. To my mind, the answer to the first question is absolutely straightforward. I'm not suggesting, never have suggested for 1 minute, that the sentences were unlawful when they were passed. But they were of a type which has since then been repudiated by Parliament. If those prisoners were being sentenced today, they would be given a determinate sentence of so many years, at the end of which they would have been released. They will be released whether or not there was a significant risk of them reoffending. Since it is no longer lawful to pass an indeterminate sentence in these cases, they should surely be brought into line, so far as is still possible, with what would be lawful now. And Parliament has paved the way by enacting Section 128. So I would suggest that the time has now come, indeed has long since passed, when the Lord Chancellor should exercise the power that he has been given by Parliament. The only reason he has given to me, either at a meeting which I had with him or in subsequent correspondence, is that he would be interfering with the sentence lawfully passed by the judges. Ladies and gentlemen, the short answer to that argument that it has happened before, most obviously when Parliament enacted the statutory provisions for early release. An even shorter answer is that the prisoners, until 2008, the sentence was, as I have explained, mandatory. In any event, I cannot imagine judges would have any great objection, since they, like everyone else, assumed that adequate provisions would have been made for dealing with the flood of prisoners serving these sentences. So that being the only argument I've heard, I think we can safely put that argument on one side. And so I come to a possible new release test. Many ideas have been proposed. The one I would favour has the advantage of being the most simple. It would be particularly apt in the case of the 773 prisoners sentenced to 2 years or less, when the sentence was, as I've said, mandatory. Many of these are now more than 5 years over tariff. Now, as already mentioned, in fixing a tariff of, say, 2 years, the judge will have had in mind a determinate sentence of 4 years. At the end of 4 years, the offender would have been released, irrespective of any future risk. So surely the simplest and undoubtedly the fairest solution now would be to substitute a determinate sentence by doubling the tariff. This is entirely consistent with Section 128 and may well have been the sentence or the remedy which Parliament had in mind when enacting that sentence. So the two questions which I would have left to the Minister if he had been here to answer with these, but I shall have to forward the questions to him or the Lord Chancellor to answer in due time. Does he argue, would he have argued, that there is an urgent, would he have agreed that there is an urgent need to speed up the rate of release? If the answer is yes, there is an urgent need, does he agree that the fairest and simplest way of dealing with the backlog is to substitute the determinate sentence which we know the judges would have passed if Section 225, now repealed, had never been enacted. Ladies and gentlemen, it will be noted that I have said nothing at all about recent cases in the ECHR, nothing about the pressure on the Parole Board, nothing about the effect that this backlog has on the prison population generally, and nothing about the cost of keeping them in prison. I leave all that with grateful thanks to the experts on either side of me who will follow.
No, I'm fine. Thank you.
I now ask Juliet Lyon to speak to us.
Thank you. I'm delighted to be here, or slightly awed. Can you hear me okay? By the fact that I'm a non-lawyer in a clutch of lawyers. So I'm going to take the opportunity really to talk about this very much from a domestic perspective, if you like, i.e. the perspective of the Prison Reform Trust. So back at home at the Prison Reform Trust, and by the way, I'm the director. Our chair is Lord Wolfe, former Lord Chief Justice. So we were first really aware of the impact of this sentence through our Advice and Information Service. That responds to about 5,000 prisoners and their families each year. And I guess, as well as helping individuals on a daily basis, acts as a scanning device for what may or may not be happening in the justice system. So through the Advice and Information Service, we started taking calls from family members and letters drawing attention to this particular sentence. And to be fair, at that stage, when the sentence was first enacted, there was a very high degree of confusion. So families would say, my son has been given a sentence, and he's been told that he's got a, whatever it is, 3-month tariff, or a 6-month tariff, or a 1-year tariff. But it's an indeterminate sentence. We don't know what that means. And to be fair, we didn't at that stage know what it meant either. And we didn't know what kind of lasting impact it would have. It became obvious to us that this was the equivalent of a life sentence. It was the sort of sentence that began to attract adjectives like Kafkaesque, a catch-22 of a sentence, a maze with no exit sentence. It's been criticised by everyone that we can think of by now, including a joint review by the Inspectorate. Almost everyone we can think of has found ways of describing this sentence which show just how poorly drafted it was and how ill thought out. But I want to talk really about the people who've got caught up in it, because that's where I feel most comfortable and can make the best contribution, I think. So one of the things we decided to do quite early on was to try and produce some kind of a briefing paper which would draw together some of the things that families were telling us, some of the things that prisoners were beginning to tell us by letter and by phone calls to the advice line, and present that as part of our contribution to, at that point, a government review, because it was beginning to become obvious to government that this was a sentence that was out of control. And so, as you said in the introduction, the prisons minister, the then prisons minister, when he introduced the sentence, was asked how many people might be affected by it. He said he thought it might be as many as 900. In fact, of course, it is rather more, as we've just heard. This was Hilary Benn talking about the Act, and he said, when asked how many it would affect, it's quite difficult to know. However, we have assumed in our modelling that over time, perhaps it would take time for the effects to develop, there could be an additional 900 in the prison population. This is only modelling, of course, and the honest answer is that it's difficult to assess the effect because it depends on the court's interpretation of the provision. And if you can remember, there was always a tendency to say it was to do with the courts rather than the politicians who'd set the sentencing framework. So what are the people who started to get caught up in this? I want to draw attention to one woman in particular, because I wondered after I'd read this what had happened to her. We found some recording that had been reported by the BBC back in January, 17th of January 2007, about a young woman called Natasha who'd been remanded into prison on charges which were in fact later dropped. But while in prison, she tried to set fire to herself. After that failed attempt, she tried to start a few more fires in her cell, and sentencing her to an IPP with a 6-month tariff, January 2007, the judge said, "In prison you developed a taste for fire, but there it did no more than cause repeated damage and disruption. However, if you were to do something like that in a hostel, a house, or a block of flats, you could cause great injury. In fact, you could cause loss of life. I wondered what had happened to Natasha. It's just one of those things that sticks in your mind. And I talked to staff who'd worked with her at that point in Holloway. 2 years ago, 2012, I was in Downview Prison, and I was introduced to her nearly 6 years after she was sentenced for just a 6-month tariff. She was a very disturbed woman. She was being held in a form of segregation. The staff were doing their absolute best to respond to her as far as they could do. So they'd created a very small area in which she had a pot plant and a chair outside of her cell, a separate little area which could be her area. She'd done a lot of courses, none of which, or very few of which, were actually considered relevant in terms of the courses that might actually lead to the Parole Board considering you for release, but things like domestic science courses, and she showed me a portfolio of work that she'd been working on. The staff were very kind to her, and undoubtedly she felt safer there than anywhere else. It was impossible to imagine where she could possibly go next. If you like, she'd become a kind of a creature of that institution. That institution, incidentally, has now closed, and I don't know where she's gone, but I'd be very surprised if she's been released. As we've just heard, very few people have been released. But just to find someone like her who'd been caught in a system, not of her making, who needed so much more help than any staff member could reasonably be expected to provide, who had clear mental health needs. And we do know that 80% of the women who are serving an IPP sentence currently are there because of an arson or arson-related offence, which usually indicates a degree of disturbance. So we have caught in a net a number of people who are likely to have mental health needs and may or may not, but are quite likely to have a learning disability. When they appeared in court, they didn't present themselves terrifically well. They may have seemed quite odd. They may not have had the kind of language that was required at the time. And it seemed to us, as outsiders, that this was the kind of sentence that allowed people to, if you like, avoid making a firm decision. So in sentencing terms, to actually play both horses, to give a tariff, but also to give this extended period where you just say, this person seems risky, they might be a danger to the public, we've got some thoughts that could be the case, so we will hold them for this indefinite term. It's one of the most unfair sentences, I think, that has ever darkened the system. And as I said to you, people have variously, within the system themselves, have said time and again, this really has to stop. So if I can tell you some of the things that have happened, and I won't tread through the years as you have, which you did so very well, but I want to draw attention to particular points since this first sentence was established in April 2005. So as I said, for us, the first time we knew about it was when it hit our Advice and Information Service net. We did look up what Winston Churchill had said, and in fact quoted him in this briefing, which was called Indefinitely Maybe, by the way. What did he say about preventative detention? He said, men of little capacity or strength, that it had netted, men of little capacity or strength, whose frequent convictions testify as much to their clumsiness as their persistence in crime. So he had given a thought to preventative detention back then. What we tried to do through the work we were doing on learning disability was to produce evidence and examples that could be presented to the Joint Committee on Human Rights, because they were looking at this point, at the sentence and about the implications of it. So we were able to do that, and we were able to quote from things that had been said to us by particular people who'd been held in the net. So I just wanted to give you one example of that. If I could do. Whoops, sorry, I'll just find it. Yes, this was a young man who was serving an IPP sentence. And if you can remember, the IPP sentence, to make it more of a catch-22 or more Kafkaesque, if you had an IQ of below 80, you weren't able to do the courses, which at that point were required to mean that you could be considered for parole. If you were on medication, you weren't able to do the courses that would be required for consideration for parole. So you really were in that maze without exit. So this chap said, to lower my risk, I have to do an ETS, that's the Enhanced Thinking Skills course. But because I can't read and write, I can't lower my situation. I'm just stuck. They're saying that until I can read and write, I can't do ETS and I can't lower my risk. It's like what I'm trying to say, I can't learn no more. I've been to a special school, I've learned as much as I can, but they don't believe that. But why should I be punished for two things? I'm being punished for the crime, and again, for not being able to read and write. So clear, so clear. But that was that man's situation, and not alone in that. Very many. We know that there are a higher proportion of people in the circumstances, and even in the general prison population of nearly 85,000 today. So the Joint Committee found that indeed it was a breach of human rights, and they described it as one of their most serious issues they'd come across in the course of their inquiry. They said that we're deeply concerned about this evidence, which indicates that because of a failure to provide for their needs, people with learning disabilities may serve longer custodial sentences than others convicted of comparable crimes. This clearly engages Article 5, rights to liberty, and Article 14, enjoyment of ECHR rights without discrimination. Now, following that, there was some effort to adapt some of these courses so that people could have at least more opportunity to engage in a course that might see them heading towards eventual release. I'm going to gallop through a few of the things that happened. I mean, one of the things that runs through my head like a theme is it's a hard sentence to unwind. It was a very harsh sentence to create, but it's a very hard sentence to unwind, and the abolition is not the end of it, as we're going to hear tonight. So there have been a whole set of internal reviews. Lord Carter was asked to conduct a review. Kevin Lockyer, who was working for the Prison Service, was asked to conduct a review for the National Offender Management Service. This is back in 2007. And eventually, the set of reviews and really the pressure of the numbers alone led the then Home Secretary Jack Straw to recalibrate the sentence. But that didn't do the trick. That's the point. Although the sentence was recalibrated, as we've heard tonight, there's still a residual number, a very high number of people still serving that sentence. So what about the impact on families? We were really pleased that Jessica Jacobson, who's here tonight, and Professor Mike Huff undertook a major piece of research with the permission of the then Lord Chief, Lord Judge. It's called Unjust Deserts, Imprisonment for Public Protection. It's mostly interviews with judges, but it does include some of the material from our Advice and Information Service. So I just want to draw your attention to one letter that came into our service in November 2009. And this was the mother of a man serving an IPP sentence. And she wrote to us, initially we naively expected that our son would be released on or about the expiry of his 18 months minimum tariff, i.e. in December 2008. After all, by then, we understood, he would have served the punitive part of his sentence, having been incarcerated for 11 months of that time in a Cat B prison on a vulnerable person's wing. So he was locked in his cell for 22 out of 24 hours each day, without access to work or offender-related courses. As it turns out, our son was transferred in May 2008 to a Cat C prison, where he remains to this day. His father was very upset by the parole hearing held in November 2009. He feels that the decision not to release him had already been made prior to the hearing, and it turned out to be a kind of cat and mouse game, to wear our son down, belittle him, and reduce him to tears. The hearing had to be interrupted twice to allow him to compose himself. If he's lucky, he will have another parole in a year's time, could be 2 years, but if he hasn't done the specified course, he'll probably fail to secure his release. This cannot be right, as he's going round in circles, with the goalposts being continually shifted, so there's little chance of his being released. We, his parents, are extremely distressed by this situation. We are elderly and trying our best, as his only next of kin, to keep his affairs in order. But this is getting increasingly difficult, owing to not knowing when he'll be released. Other people have been supportive to us, but we're now perplexed as to why he isn't being released, and maybe assuming his original offence may be more serious than it was. Our health is starting to deteriorate. We worry we'll not be able to maintain this level of support, which after all is important for everyone, as it will enable him more successfully to reintegrate society when he's finally released. We feel that the situation created by the imposition of the IPP on our son for what was now not classified as a serious offence is cruel and inhumane. Time. Well, I would like just 2 more minutes if I might beg you for those. So I'm trying to give you really a flavour of the kind of things that reach our office day in, day out. We're currently in correspondence with about 150 people serving an IPP sentence. They're constantly asking for more information. The Prison Service Order, which was changed after the Legal Aid and Sentencing Punishment of Offenders Bill, LASPO, after the Act was passed, we hoped that by changing the Prison Service Order, taking account of the views of staff, this might make it somewhat easier for people to progress towards their release. Remember, this is a sentence that's been criticised by the Prison Governors Association. Those who work in the system find it a very hard sentence to administer. And it does, I think, destroy the legitimacy of a system that needs that legitimacy for it to be the kind of service that we all can respect. I wanted to end on a lighter note, if there's anything possible that you can say that's light about this, but I found something. We have a prisoners' writing competition, which about 500 prisoners took part in towards the end of last year. And one of the judges, Chris Mullin, particularly liked this, former trustee of ours. This was a satire written by somebody serving an IPP. And he said in his essay that he'd written that it should be called an IIPP, so an infinity imprisonment for public protection. And I won't read you all of his essay because there isn't time, but essentially what he said was, and it was just a satire about this, he said that his sentence was for thinking about not living in London and that was a crime. And because he'd thought about that, even though it was a dream while he was asleep, he was sentenced to this infinity sentence. And that campaigns and petitions were started until the prison service came up with a solution, because people were so outraged that people were dying before they finished this sentence because it was infinity. They died. So the solution was to freeze people so that they could still serve the sentence forever. I mean, it was only when their bodies took up too much space, frozen, that they had to come up with a new idea, which was beheading people and keeping them alive with their heads in glass jars on life support systems. It's grim stuff. I said it was light. It's very, very grim, but it's quite funny. And he's found a way of talking about his situation which just about keeps him alive. But this isn't tenable. There are, as we've heard, thousands of people in this situation. There are things, as we've heard, that can be done about it. Families are meeting next week to talk in Parliament about this very issue. And I really appreciate that people have come here to think about it tonight. Thank you.
Thank you. I now ask Sir David Calvert-Smith.
Well, good evening, everyone. As you've heard, I'm the current chairman of the Parole Board. The history of sentencing legislation, ever since sentencing policy became dominated by the twin desires of keeping the prison population down on the one hand and being tough on criminals on the other, has been a checkered one. In 1991, Parliament passed a Criminal Justice Act which astonished sentencers, of which I was one as a humble Crown Court recorder at the time, by requiring sentencers to ignore, with certain limited exceptions, the previous records of offenders when they sentenced them, on the basis that having been punished for the original offences, they shouldn't be effectively punished twice for having done it again. In 2003, effective from April 2005, as we've heard from Lord Lloyd and from Juliet, the pendulum swung very decisively in the other direction and has remained fixed in that other direction ever since. The country, it seemed, had room enough for more prisoners and enough money perhaps then to build more prisons if necessary. Who knows? Previous relevant convictions became a statutory aggravating feature, so that in 12 years, the exact opposite of what had been the sentencing law became part of our law and still is. Parliament decided that too many people who were being released from prison who were, inverted commas, dangerous, thus putting a public, or a section of the public at least, at the unacceptable risk of serious harm. Hence the regime which you've heard outlined by Lord Lloyd. There was an additional concern, fueled by press headlines which highlighted cases in which a newspaper or newspapers believed that a sentence passed in a particular case was too lenient. Cases, in fact, in which the Attorney General or the Solicitor General had successfully persuaded the Court of Appeal that the sentence in an individual case was unduly lenient. Parliament added the assumption about which Lord Lloyd has told you. No doubt because there was a feeling within the government of the day that judges were weak and woolly do-gooders who would not otherwise perform the responsibilities they had to the public, so that they were told that they would jolly well pass these sentences because even if in their pink and woolly private life they would not have dreamt of doing so. Of course, that last assumption was way out of line. Many judges, as can be seen from the figures, obviously embraced these new sentences, aided and abetted by an increasingly risk-averse probation service, itself suffering the damage of 2 or 3 very high-profile cases in which people on licence had gone on to commit very serious crimes. They were then under instruction from their bosses to be risk-averse, and therefore the probation reports or pre-sentence reports, which as a recorder and then a judge I used to receive, got more and more risk-averse and more designed to tell the judge that in his or her view, the probation officer's view, this person did indeed represent a significant risk of serious harm and they should therefore at least be considered for an IPP sentence. So that's what got us into, if it is a mess, this mess, in my opinion. The Court of Appeal Criminal Division, which came down pretty hard in 1 or 2 instances on other provisions of the Criminal Justice Act and limited the effect, for instance, of the admission of previous bad character as evidence, the new hearsay provisions, which let in a lot of evidence which would otherwise have been inadmissible before. But so far as IPP sentences were concerned, not much was done by the appellate courts to push circuit judges away from imposing these sentences. They have imposed on themselves a kind of Wednesbury test. Was it entirely beyond a reasonable judge to have thought that this person was dangerous? If it wasn't, well, then the sentence would stand. So that, all those things have created this situation. As Juliet's organisation said in 2005, prison is now being used increasingly not as a place of measured punishment, but as a place of containment for public safety. Of course, the Parole Board became the gatekeeper for all these people, having previously only been the gatekeeper for those sentenced to imprisonment for life and certain other offenders under sentencing provisions which have had fairly short life. They have slightly longer life than the IPP sentence. The now single test for release, as you've heard, is that contained in Section 28(6)(b) of the Crime Sentences Act 1997, quotes that it is no longer necessary for the protection of the public that the prisoner be confined. That is the single test to which all Parole Board panels work when considering prisoners, whether they be lifers, IPP prisoners, prisoners who've been recalled for breach of their licence, and so on. And the key moment for us is, of course, the moment at which we are considering the prisoner. We cannot, for instance, review the finding of dangerousness. We have to accept that as a given. That's what the court decided. Maybe the Court of Appeal blessed it. That's a given. We can't act as a Court of Appeal. And therefore we have to deal with the assumption that the sentence was rightly imposed. it would be quite wrong as me, as chairman of an independent tribunal such as the Parole Board, to express any concluded opinion on the way forward. We are a statutory body. We will do exactly what we're told by Parliament when it tells us what to do it, and if the test that we have to apply stays the same, we'll apply that one. If Parliament decides, or the Minister by order decides that it should be a different one, we will apply that test. Of course we will, and it would be wrong for me to try and persuade Parliament to do one thing or another. What I can do, perhaps, though, is, first of all, confirm the current situation. There are many, many prisoners still in prison who have long passed their tariff or, inverted commas, punishment period, but have not been released because the assessment of the Parole Board has been that they do still risk a significant risk of serious harm. And, of course, to indicate that the Parole Board will suffer consequences of one kind or another according to the changes that may be instituted. The change that was instituted, of course, caused something equivalent to the 7 bore so far as the Parole Board was concerned. Nobody predicted, as Lord Lloyd has said, the large numbers of people who would, in due course, come before the Parole Board for consideration after an IPP was introduced. As is the way with this sort of sentencing provision, and indeed is the way with the new sentencing provisions, which I'll mention in a moment, the 7 bore takes a long way to get down to the mouth of the river, so that the full effects of the IPP sentence only started to be felt several years later, albeit there were a number of short tariff sentences who came up for consideration quite soon. The vast majority were longer tariff sentences whose sentences come up for review and are still coming up for review, and indeed the peak of our work for initial IPP sentences has still not been reached. We will probably reach it by the end of this year or the beginning of next, before those who, for instance, got a 6, 7, 8, 9, 10-year tariff come to us and then start falling away as the prisoners are released. So that was one effect. It resulted in an emergency recruitment process by the Parole Board, which increased its size enormously, and the Parole Board is now doing an unimaginable quantity of work compared to the sort of work it was doing perhaps when Lord Lloyd was a member of it. We've also had to cope, this is just on the side, but it's going to affect us for years to come from the recent judgment of the case of Osborne, Booth and Riley, which means that we will be hearing having oral hearings in a very, very much larger number of cases than we did before. Well, that's the effect on us of the IPP. Sadly, as must be the case, I can't speak for individual panels, of course, but sadly, in many cases, maybe the sort of case, that tragic case which I was greeted with by Juliet almost my first week at the Parole Board, of the lady who committed arson in prison. A number of prisoners make no progress. Indeed, sometimes the prison environment may be totally inimical to progress, quite the reverse. They may even go backwards, so that it becomes very difficult for the professionals who are giving evidence to us, the offender supervisor, the offender manager, maybe the psychiatrist or psychologist, to say, well, actually the risk has decreased. They frequently have to come to us and say, well, I'm sorry, this person is as, if not more dangerous now than he or she was when she came in. So that it becomes very difficult in those circumstances for the Parole Board to direct release. It has to be said, perhaps since nobody's going to say a single word in favour of the sentence, perhaps I might just say one or two. A number of members have told me that they have seen prisoners who have come to the realization that they are now in what is effectively a life sentence, because as Juliet rightly said, I don't think any of them probably realized that at the time, and have realized that actually, unless they turn their lives around, they may never get out. And some of them have, and have been released and gone on to lead law-abiding lives within the community, and so that the IPP sentence, in the opinion of some of my members, and in some cases, has probably been an advantage to that person who would otherwise have been in the revolving door getting longer and longer determinate sentences had that not happened. But that's perhaps does not, of course, attack the problem which Lord Lloyd is focusing on. Well, on the assumption that Parliament accepts in due course that there is a problem, what are the possible solutions and what are the likely consequences for us and for the IPP population? Well, one solution is to order the immediate release of, in brackets, some prisoners who have served the tariff period, the 50% of the determinate sentence that they would otherwise have received, or if they'd served double the tariff, or some other figure, i.e. a mathematical calculation, if you like. If you hit that spot, whichever spot Parliament decides it's going to be, you're out. This could be done by passing primary legislation or by the use of Section 128, as suggested by Lord Lloyd. Of course, the mathematical solution has the virtue of simplicity. The Parole Board would then not be making a decision on suitability for release or risk, because that would have been made by Section 128 for it. The only decision the Parole Board would then be making, if it still had the cases, was seized of the cases, would be on the licence conditions, which would be appropriate following release. So that those hearings, if we had to have them, would be, we, the Parole Board, that would probably have to be called something different, because they would not be parole hearings in the old sense. They would be licence condition hearings. So that's certainly a solution which would have that effect. We will be conducting a different sort of hearing for those prisoners who had hit that mathematical limit, so that their release became automatic. What other types of amendment have been suggested by Lord Lloyd, among others, and discussed? One was the possibility that the burden of proof should shift. That's an attractive solution, and it, certainly if it was done, would send a message, if you like, to the public. However, again, canvassing my members, the view that they take is that would make very, very little difference. The Parole Board does not apply burdens and standards of proof. It simply looks at the answer to a question. What is the risk this prisoner now poses? Of course, if all the reports are in favour of release, well then the case is probably the prisoner's to lose, because if the offender supervisor and the offender manager are recommending release and have got a release plan, somewhere to live, conditions in place, well, unless the prisoner makes some terrible mistake during the hearing, or something comes up during the hearing, then he's likely to be released. Per contra, if all the reports are saying this person didn't do the course properly, didn't turn up, clearly displayed no victim awareness, whatever the reports say, well then it probably is his to lose. I say his to win rather, because the professionals whose reports the Parole Board rely enormously on, because they've actually seen the prisoner and dealt with him, it's likely that it's unlikely that he will win. But again, the burden of proof and the standard of proof in that context, in the opinion of my members, rightly or wrongly, they suggest is probably not going to have much practical effect, even if the wording changed, because the key question is, what is the risk? Is there a risk, significant risk still of serious harm? Another solution, which I put forward for consideration, is the immediate conversion of IPP sentences into the new form of extended sentence, not a sentence which Lord Lloyd had time to mention, but which has now been introduced by the Legal Aid Sentencing and Punishment of Offenders Act 2012 as an alternative to IPPs, effectively. Some IPPites, old IPPites, will now get life sentences under this act. So right at the top end of the scale, there will be some more life sentences, because LASPO provides for more, as we used to think of them, discretionary life sentences to be applied. But that's right at the top end of the scale, not the sort of offending that Lord Lloyd's been discussing. The new extended sentences, which with maximum extension periods of 5 years for violent, licence periods for 5 years for violent offenders and 8 for sexual, the sentence consists of a custodial term to reflect the seriousness of the offence, followed by the extended licence determined by the court on the basis of what the court considers, quotes, necessary for the purpose of protecting members of the public from serious harm, i.e., almost exactly the same words as for the IPP sentence. For the new extended sentence, release will normally be at 2/3, unless the custodial term is 10 years or more, or the sentence is imposed for a listed offence in Schedule 15B, which are really serious offences, not the old simple arson, not so serious offences, when the case must be referred at the 2/3 point to us at the Parole Board, so that you won't get out automatically even at 2/3 on an EDS if it's a very serious offence until the Parole Board. But of course you will get out at the end of it. It is not an indefinite sentence, that's the key difference. So one possibility, if it's thought the change was necessary, would be to convert the IPP sentence into a form of extended sentence, which would A, ensure guaranteed release for some prisoners at 2/3 and guaranteed release for all prisoners at the end, and a licence period, again, with limits, unlike the IPP, where you're on licence for life. What's happened since I became chairman, it's the last thing I'm going to say, is that we have introduced into our parole guidance to members the fact to be taken into account as one of the many factors we list when making the final decision, the length of time, if it be the case, that the prisoner is over tariff. So that is now within our remit, as it were, as Parole Board members. Of course, in the end, if the risk is the risk, then the risk will trump everything, because we can't be seen to, under the current test, to let out prisoners whom we believe to present an unacceptable risk. The one thing I would want to avoid on behalf of my members and the Parole Board's standing and public confidence in it generally would be the Parole Board having to direct the release of prisoners whom it believed should not be released because they were at imminent risk of, for instance, taking revenge on a witness or on their spouse or whatever it was, save and except a clear boundary having been set, so that if you're coming out at double your tariff or whatever the tariff set is, then is it absolutely clear that that's why you've come out and not because the Parole Board thought you were suitable for it. But my worry is, because the Parole Board will be thought of within the public consciousness of somebody who does, as a body that does take a reasoned decision and weigh things in the balance, that we run the risk of being, as it were, criticised for something which we haven't created. But that said, that's quite enough from me.
Well done.
Weatherby, please.
Thank you very much. Can I start by saying how pleased and flattered I am to be asked to appear on such an important panel and in front of such an audience. Can I start by taking a leaf from Sir Sydney and starting with a couple of quotations, although I warn you in advance that these are quotations which are unlikely to last for a century, as the one that Sir Sydney read to us before. And I quote, it is not a situation which anybody in my position would have wished on their worst enemy, still less on themselves, but here we are. I am trying to work through it as quickly as I can. Those are the words of the Secretary of State for Justice himself, whose government had only 30 months before piloted the IPP legislation through Parliament. It was about 4 years later that the new Secretary of State for Justice, Ken Clarke, came before Parliament in a debate and said the following: "What is wrong is that indeterminate sentences are unfair between prisoner and prisoner. The Parole Board has been given the task of trying to see whether a prisoner could prove that he is no longer a risk to the public. It is almost impossible for the prisoner to prove that, so it is something of a lottery, and hardly any are released. We therefore face an impossible problem." Now, of course, Ken Clarke was the minister who then piloted the solution through Parliament with the 2012 Act. I'd like to make 4 points, and I'll make them as briefly as I can. The bringing into force of the IPP sentences was plainly a mistake of the highest order. How was it that the government of the day allowed such an error to be made? The answer to that question, in my view, is an important one, not just for history, but for the debate that we're having tonight itself. Just imagine if you had been the Secretary of State for Justice and you were considering bringing in this massive change of penal policy, bringing that into force. What might you have done? Well, you might think you'd have asked your senior civil servants, your senior staff in the Ministry of Justice, to research how other comparable countries approach such offenders, to see if there is comparative learning, for example, which could inform your approach, and frankly whether it was a good idea or not. Well, if that had been done, the comparative research would have shown that other countries, other comparable countries, have indeed tried a variety of measures to combat recidivism, to combat those relatively small number of offenders who have such psychological problems that perhaps they ought to be committed to clinics. But what the comparative research would not have found is a comparable country which had instituted a system which had led to the indeterminate, the indefinite incarceration of such a huge number of offences. Now, of course, the fact that other comparable countries haven't thought of it doesn't of itself mean that it's wrong, but it might just stop and make you think. You might think that a Secretary of State who was going to pilot such legislation through a Parliament might have asked the Prison Service or the Parole Board what effect such provisions might have had and what sort of resourcing might be needed to make them function. Well, I've no idea whether these questions were asked or whether they weren't. But you might think that if the Prison Service had been asked what would happen if you tripled the number of life sentence prisoners, because that's what these provisions did in a very short number of years. The prison service would have said, well, yes, we can do it, but you'll have to give us tens, probably hundreds of millions of pounds to do it. Now, I'm not exaggerating there. I'm going to do a little bit of maths with you in a few minutes, if I may. But IPP prison sentences, if they were to work at all, were enormously resource intensive. They had to be accompanied by a very large number of courses and treatments, many of which would go on for months, if not years, involve highly skilled professionals, and of course very expensive indeed. Anyone who knows anything about lifer prisoners know that lifers tend to spend a lot longer than determinate sentence prisoners in prison. It's very, very expensive to keep people in prison. So that's where I get to my figure of many millions, possibly hundreds of millions. If you'd asked the Parole Board would have said, well, hang on a minute. If you're going to triple the number of lifers, and you're going to give many of them very low tariffs, they're going to come before the Parole Board very, very quickly. But yes, we can make it work, but you're going to have to properly resource the prison service so that those sentences can work. And so we, the Parole Board, will be provided with the requisite evidence by which we can do our job. And by the way, you're also going to have to increase our funding exponentially to provide the requisite number of panels by which the job that we do can be done. And of course, none of that happened. You might have, you the Secretary of State for Justice, piloting this sort of legislation through Parliament, you might also have asked a lawyer or three about the implications of all this legally. The lawyer looking at this legislation would have said, well, hang on a minute, what you're doing here is you are compelling judges. These were mandatory sentences. You're compelling judges to hyperbolically increase the number of indeterminate sentence prisoners, and of course that would lead to massive funding issues, or the system would grind to a rather sorry halt. By the way, the lawyer might say, if the system doesn't work, you're going to end up with a cohort of prisoners who have served their just deserts for the offences that they have committed, the commensurate period of imprisonment for the level of offending, but who have little or no prospect of progressing towards release. In short, the lawyer might have said that you will end up arbitrarily detaining a number of these prisoners, as indeed a case law has come to pass. There would be claims, and the system, quite frankly, would fall into some kind of disrepute. If these steps had been taken, you might think that Chapter 5, Part 12 of the 2003 Act might not have made its way to the statute books, because the Secretary of State would not have advanced it, Parliament would not have passed those laws. So why, apparently, did this not happen? The only conclusion that I could put, and it's a very personal point I put across, is the moral compass had become disturbed. The executive was taken with this idea of being tough on offenders, tough on criminals, to the detriment of any serious approach to penal policy, to looking at these issues in any kind of joined-up way, and with respect for liberty, for human dignity, for public safety ultimately, and indeed respect for the law. So my second point, following from that, is that where it becomes so apparent that a law is so completely defective as the 2003 Act provisions were, particularly a law which affects liberty to such a degree that the adherence to the rule of law requires some kind of pretty urgent remedial action. I hardly need to say to present company what the privileged position of liberty is within our system, which goes back well over 1,000 years. The failure of the IPC system meant that post-tariff offenders who'd served their just deserts, were being warehoused rather than progressed through the system. And that's ultimately what led to the Court of Human Rights in 2012, at about the same time as the government had reached the conclusion that it should repeal IPPs. It was the conclusion of the Court of Human Rights that detention was becoming arbitrary and therefore unlawful under the Convention. The failure to face up to the IPP problem meant, of course, that the country ended up with something like 3 times the number of indeterminate sentence prisoners as it had before, as Lord Lloyd has pointed out already, more than the whole of the rest of Europe together. A large cohort of whom had short tariffs but had very little prospect of progression. Of course, as I've said, it's to this government's credit that it abolished IPPs with the 2012 Act, but only prospectively. But it, of course, enacted this provision, which was expressly designed to deal with the ongoing problem of the 5,000 existing prisoners. However, and regrettably, the position then stalled, and we remain now in the position where it's quite clear that many of these prisoners are serving far longer than they should. And that leads to the position of it being arbitrary detention. What is needed is an urgent remedy, and I'll go on and deal with that in a little bit of time. But what appears to be the position of the current Secretary of State is that he feels powerless to do anything about it, because to change the test of release will somehow change the original sentence. Well, with great respect, I beg to disagree. There is good authority, recent authority. I was in one of the cases, I lost, incidentally, which established that the judge passes the sentence without regard to when the sentence comes to an end. The mechanism by which a sentence comes to an end is set by Parliament. Sometimes it involves the Parole Board or a calculation by the executive, but it can change, and there are various changes that have been affected by Parliament, or sometimes by changes of executive policy. All of this is very well established in the common law and also by statute, and indeed it's quite clear that Section 128 was absolutely enacted for this one sole purpose. So the very notion that the release test can't change, because that would change the original sentence, is, I respectfully say, completely wrong. It can't be right. The failure to rectify the IPP problem, I would say, undermines the rule of law itself, because law requires respect for its aims. A principle underpinning the public law requirement that ministers act within the legislative purpose of a statute is a rule of law fundamental. My third point and I'll deal with it quickly because it's been raised before, is the cost. The cost of the IPP problem is phenomenal. The cost of incarcerating prisoners is not entirely easy to find, but it appears, the figures that are generally quoted, are that it costs between 40,000 and 60,000 to detain a prisoner within our system, depending on what kind of prisoner we're talking about. IPP prisoners, of course, are particularly expensive because of the requirements for courses and treatments and assessments. And of course, there are the add-on costs outside of the prison system of the Parole Board itself. If we were to take a mid-part of that range, if we were to say that IPP prisoners on average cost £50,000 a year, then do the maths. There's 5,000 of them. On my calculator, that equals £250 million per annum. A huge cost. I'm running out of time. I'll speed up. We're facing government cuts to legal aid. The whole of the prison law legal aid spending is £22 million per annum. The savings that the government are trying to achieve by cuts to criminal legal aid are £220 million per annum. It appears that the money being lost by the IPP problem is more than either of those. My final point relates to remedy. There is an imperative, I would say, that there has to be a urgent change to the release provisions for IPPs. And I have little to add, really, to what's been said on that, save for this one point. And I slightly leave company from Sir David on this, that I do think that it's important that we look again at the general test for indeterminate sentence prisoners, and that we, in effect, reverse the burden. Because although it's been said that there is no burden, in effect what happens is that the prisoner has to prove a negative. What we have in many of these IPP cases is a failure of the executive to provide the courses or the assessments that are required for Sir David and the Parole Board to do their job properly. If you reverse the test, you require the executive to provide those resources.
We have a little time for questions, not very much, but I'd invite anyone who has a question to ask it of members of the panel, and I say questions rather than speeches. I think I saw the first there.